Hello everyone, let's discuss today's The Hindu editorial page. The first article is IT searches, a form of extra constitutional power. In this article, the writer says that in August 2017, the Supreme Court of India declared that the Constitution of India guaranteed a fundamental right to privacy for persons. This verdict was expected to help usher civil rights jurisprudence into a new era, where our most cherished liberties are preserved and protected against arbitrary and whimsical governmental excesses. The 6 separate judgments in the case spoke through a common voice, placing the individual at the heart of the constitutional discourse and subjecting any state action impinging on our privacy or any allied right to the most piercing scrutiny. However, when it comes to interpreting our statutes, the meaning ascribed to our rights has remained unchanged. The promised culture of justification, grounded in principles such as proportionality, is rarely on display. Instead, permeating the conversation is a culture of judicial deference, where our laws continue to be construed on lines that vest absolute authority in the executive. A notable example of this feature is the use of Section 132 of the Income Tax Act, 1961, which grants untrammeled police power to forcibly search persons and their properties and seize goods found during such a search. While this measure can be undertaken only where the authorities have a reason to believe that a person has failed to disclose his income properly, the purported foundation underlying a search is subject to little safeguards under the statute. The income tax law was refashioned in 1961 with Section 132 providing express powers of search and seizure. This provision was challenged by the Supreme Court in Puran Mal versus Director of Inspection, 1973, which relied heavily on its own judgment in MP Sharma versus Satish Chandra. The court emphasized that a power of search and seizure is an overriding power of the state for the protection of social security and must be regulated by law. However, the court's interpretation of the law has since changed, and the right to privacy is intrinsic to the right to personal liberty guaranteed by Article 21. Today, the state's power to search and seize cannot be viewed as a simple tool of social security, but as a rule subject to the doctrine of proportionality. For it to remain lawful, its use must be intended for a legitimate aim. The measure adopted must be rationally connected to its objective. No alternative means must be available to attain the same purpose, and a balance must be struck between the means chosen and the right that is violated. A bare reading of Section 132 of the Income Tax Act suggests a breach of this principle. In Principal Director of Income Tax Investigation and Ors versus Laljibai Kanjibai Mandalia, the court paid no heed to its ruling in Puttaswamy, finding that the formation of an opinion necessitating a search was not a judicial or quasi-judicial function, but was only administrative in character. The court should look at whether the formation of the belief was honest and bona fide, adopting the Wensbury principle, derived from the UK Court of Appeal's 1948 judgment in Associated Provincial Picture Houses Limited versus Wensbury Corporation. Post-Puttaswamy, there should be no place for the Wensbury rule, especially when fundamental rights are at stake. Our constitutional canon demands that any executive action conform to statutory law in the strictest sense. The next article is The Blood Management System Needs a Fresh Infusion. In this article, the writer says that the COVID-19 pandemic has highlighted the inequities in public health worldwide, leading policymakers to endorse the need to improve the global health architecture as a tool for economic growth and securing the future of the planet. Key aspects include greater health financing through international collaborations, deepening the adoption of digital health solutions, and increasing access to medical countermeasures. However, prioritizing access to blood and its products remains fundamental to building a resilient global health architecture. Blood and its products play a crucial role in various medical scenarios, including scheduled surgeries, emergency procedures, and treatment of conditions such as cancer, thalassemia, and postpartum hemorrhage, PPH. This underscores their irreplaceable significance in upholding patient health across a spectrum of healthcare needs. A recent report by the World Health Organization, WHO, has brought attention to global disparities in blood collection. Countries in the WTO African region could only collect 5% of the global donations, while low-income and lower-middle-income nations receive 2% and 24% of the worldwide contributions, respectively. India, for example, faces a perennial shortage of over 6 lakh blood units, impacting critical healthcare services. The advantages of a hub-and-spoke model are that inequities in access to safe and sustainable blood can be mitigated through the establishment of robust public-private partnerships, PPP. Collaborations between leading industry players hold immense potential in introducing innovative models for blood collection and distribution, effectively addressing numerous existing challenges. The hub-and-spoke model is one such innovative method where high-volume blood banks act as a hub for smaller blood centers. This model can be particularly relevant for resource-constrained settings in low- and middle-income countries, LMIC, as it can address critical gaps in blood availability and distribution, thereby enhancing the accessibility and availability of blood and its products. As the shelf life of blood and its products is short, a hub-and-spoke model would help optimize their utilization by smaller blood centers. This innovative approach streamlines distribution, ensuring that vital resources reach their maximum potential while reducing losses from expiration. Over the course of 3 years, from 2014 to 15 to 2016 to 17, a surplus of 30 lakh blood units and related products were discarded due to expiration, degradation during storage, and lack of proper disposal. The next article is Striking Fear. Driver strike is a test for severity of hit-and-run clause in new penal code. In this article, the writer says that the Bharatiya Nyaya Sansthan (BNS) provision, which treats hit-and-run accident cases as an aggravated form of offense for causing death by rashness or negligence, will be the first in the new code to be scrutinized for its severity. The government has promised to bring it into play after consultations with the All India Motor Transport Congress. However, the truck drivers' body has taken the stand that the strike was primarily resorting to by the drivers who feared additional criminal liability. Section 106 of the BNS will replace Section 304A of the IPC, which punishes causing death by rash and negligent act that does not amount to culpable homicide. The existing section provides for a 2-year jail term. Section 106 has 3 components. It prescribes a prison term of up to 5 years, besides a fine, for causing death due to rash or negligent acts. It provides for reduced criminal liability for registered medical doctors of 2 years in jail if death occurred in the course of a medical procedure. And the second clause concerns road accidents where the person involved escapes without reporting it soon after the incident, may extend the imprisonment to 10 years and a fine. The question is whether the law should focus on raising prison terms or on a comprehensive accident prevention policy package covering imprisonment, compensation, and safety.